Hi guys, this is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is January 23rd. This is a community conference call. As usual, I will first answer the questions that have been posted. Then I will answer the questions that are follow-ups on the posted questions. And finally, we'll take new questions. I think we'll have enough time to take quite a few new questions because I usually go through these questions fairly quickly. First is from Gaurav Sharma. He is waiting for a green card through family-based case. And his question is, can I apply for a visitor visa? And the answer is yes, you can apply. Whether or not you're going to get it is entirely up to the discretion of the consular officer. Usually, they do not give tourist visas to people whose green card applications are currently pending. You also wanted to know how long would it take for you to have your green card. You have to rely on Visa Bulletin. You must know where that is. It's on our website. It's all over the web. Many websites have it. So the way it works is the Visa Bulletin for 1 month tells you what the visa numbers are going to be for the following month. So about the 15th of, let's say, January, we find out from February 1st what kind of visa numbers are we looking at. So follow the Visa Bulletin for that. Can you help? Can I help? For your visitor visa, I'm not sure, Gauravji, what I can do. There really is not much we can do. It's a matter of discretion. The consular officer does have a lot of discretion, and we can't really legally challenge it unless they do something so wrong that somebody else would look at their case and say, well, this is an error. We've been successful in getting some tourist visa denials overturned, but those were uniquely good cases, typically where somebody has come to the United States and gone back several times, and then inexplicably, without any explanation, government decides to not issue them a visa again. Those kind of cases, we have a good chance, but a case like yours, I'm not sure I can do much for you. Okay, next question is, what could be done to keep my mother with me in here beyond her visa time? June, if you look at our cases from our files, there's a column on our homepage. We have a couple of cases like this. One case was that of the parent of a doctor, and that's the dad, was alone and had nobody to take care of him in India. And we were able to keep extending the tourist visa by several years. There is actually a provision in the Foreign Affairs Manual for these kind of visas, which is referred to as B1 in lieu of derivative visa. That's not a technical term really, but that's the way I refer to it. The idea is, if somebody is on H1, like you are, and my mom is in Nepal, she is the only one there. I am here with my family, but she can't qualify for an H4. So in those cases, if she enters on tourist visa, often we can keep extending the tourist visa status or the tourist status based upon the fact that her family is here. She does not qualify for H4, but we should be able to keep extending her tourist visa or tourist status. One good idea in these cases is to make it clear both to the consulate as well as to the CBP at the airport that your mom intends to stay here and intends to keep extending the tourist status as long as the law permits her to. Okay, so it's possible to do that. Then next question is from Sai. Presently in India, got H1B stamp with current employer A. Haven't been to the US. Now there's another employer who wants to file an H1B transfer. So the question is, can I use the same visa stamp? So I've got the visa stamp through one employer, never joined them. But without joining the first employer, can I get H1B transfer? Of course you can. Can I use the same visa? That's a little bit doubtful. Here is the situation. If you were already in the United States and had a visa stamp, and then you changed an employer, you could use the same visa stamp. But in a situation like yours, where you have not yet used your visa, we've had this discussion with the consulates at various times. Consulates have indicated that they want us to get a new visa stamping. Um, it's To me, it doesn't make any sense because there appears to be no legal reason for it. What is the difference if you do it within the United States or if you do it outside the United States? What I would suggest is, and I'm aware of the Foreign Affairs Manual provision that you've quoted, um, um, I I think it'll be a good idea to just correspond with the consulate. And you can show them the same excerpt from the Foreign Affairs Manual. Remember, the FAM is binding on the consulates. FAM, Foreign Affairs Manual, is binding on the consulates. So you can send this in an email and let me know what they say. It'll be interesting to see if they've changed their mind about this. You can send me an email to help@immigration.com if you find out something different than what I just said. So in my view, consulates are of the opinion that you should get the visa stamping done again if you have never used the visa and you want to transfer over to a new employer. If you are within the United States, you would not have to change the visa. Next question is from Shekhar. Same question as the previous user. Can I travel? I'm in India. I do have valid visa stamp on H-1B from my current employer. Right, and it's the same answer, Shekharji. You can actually use the same um, information that Sai has provided up in his question. If you are already in the United States and then you change employers, you can use the old visa stamp. But if you've never been to the US, it is best to check with the consulate what their current thinking is. Johnson is just saying hi to everyone, so we go on to the next one. Uh, this is from user Graves. Permanent I-140 have been approved after 6th year, so he's outside the country. H-1B extension was denied after the RFE. So the question is, if my H-1 petition is rejected again with the same client, can I refile with another client location? And the answer is sure. I don't know what the grounds of denial are. So the client's work order said that your work location is offshore. Therefore, they denied the case. You can apply again. I don't see any problem with that. Is there any maximum number of times an H-1 extension can be filed? There is no maximum number. You can file it as many times as you like. Can I switch jobs and still continue with my priority date? Then the answer is yes. As well as my H-1 extension, yes. If your old employer does not revoke your I-140, you can get the extension through another employer. Okay. So I think that pretty much takes care of your questions. Let's go on to I'm kind of technically challenged today. I was telling people that I have tried to split the screen. I didn't bring my laptop today, my notebook. Okay, so this one I've taken care of. Dependent naturalization. So this is a case in which husband and wife met in 2003, lived together 5-6 years, got married in 2006. So from 2003 to 2006 they lived together. 2006 to 2009 they lived together as husband and wife. 2007 green card was filed. They separated in 2009 and green card was approved while they were separated, but they intended to get together, or they could have gotten together. Does this affect citizenship? It's a little difficult question for me to answer. The problem here is this, ma'am, that USCIS has taken this very strange approach that if a couple are legally separated, they can deny a derivative green card to the spouse. I don't think they can. I think until the divorce is final, people are still married. So for USCIS to take the position that somehow legal separation makes the derivative beneficiary ineligible to receive her green card, I think this is a wrong legal approach. Nevertheless, that's what they've taken. And if this comes up during the naturalization, they could create an issue for you. My advice would be to apply for naturalization after your 5 years are complete, not 90 days before the fifth year of your green card, fifth year of your green card approval anniversary. So I would just do it after 5 years. The legal reason for that is this: if you file for naturalization within 90 days before the fifth year, government can come after your adjustment of status. Okay, because under the law, adjustment of status can be revoked within 5 years of approval. It's very easy for them. If 5 years have passed, they then have to take you to immigration court to try to take away a green card. It's much more difficult. Okay, so do it after 5 years. If they take the position that you were legally separated and we are going to not only deny your naturalization but come after your green card, contact me. I think that's the legally wrong approach to take, but I'm cautioning you that they do take that approach at times. Next question is about left USA voluntarily while on withholding of removal status and want to come with a visa. So they were here on F1 visa, went to, then they obviously fell out of status, then they were put in proceedings, got withholding of removal, and left voluntarily. It's been more than 5 years, so the question is, can I get B1, B2 to attend a medical expo? Do I stand a chance? And I think you do. You do. It appears to me that, well, at least as far as the period outside the United States is concerned, I think you've been long enough. You should be able to make it back, or if not without a waiver, then with a 212D waiver, which you can get. But the question is B1, B2, which is a discretion visa, appropriate for your situation? Can the consular officer take the position that, well, in our view, you have violated status before, so we are not going to give you a B1, B2, not because of anything else, but because of that violation of status? And the answer is yes, that's definitely a gray area. What are your chances of getting sponsorship by her, and how long will it take? Unfortunately, I can't switch screens right now, but look at the visa bulletin and look at the category that applies to you, which is married adult, children of US citizens. See how long that's taking. That should give you an idea. Okay. H1 approved but no client letter for stamping. Can I transfer it to another employer before stamping? So in 2013, you were in the US and you worked for a company X on L1. The same year, H1 was filed with company Y, got approved, came back to India because the L1 extension was rejected. Let me guess, it must have been an L1B. Then left company X and joined company Z. Still in India, H1 petition is approved, but company Y is not able to arrange a client letter. So you can't go for visa stamping. So questions are, is it possible for me to transfer my visa to company A without stamping, another company? And the answer is, you can transfer your visa without stamping. That's not a problem. And you don't have to have pay slips from the company that initially sponsored you, which is company Y. So one of your friends in US runs his own company with self-employment. Can I use his company's client letter? No, not unless it's a truthful situation. Do not make things up. This can be ground for criminal prosecution and permanent bar from entering USA. You must always be truthful. So the question number 3 is that my mom is coming to the US to attend a conference. Can I come with her on a tourist visa? And the answer is, I can't predict that. Nobody can really tell you if that's going to work or not. Okay. I doubt very much they're going to consider this to be a genuine case, but you can try. Also remember, if you go for a new visa stamping, consulate does have the option of, well, hang on, you don't have an H1 visa stamping. So there is no negative impact if the tourist visa is denied. Only thing I would be careful about is don't lie about anything. Whatever you tell them truthfully. Okay? So the chances of getting a visitor visa are small. You can try. I don't think you're going to get it. But the fact that a visitor visa is denied should not have negative impact for your H1 in future. So the question is from Zach has it. He wants to know, in the following scenarios, is there going to be any correspondence with my previous employer or their attorney? Filing of AC-21 or AOS porting by new employer. There should be no communication with your employer. However, if a new G28 is filed by a new lawyer, your old lawyer may be able to find that out. They may be able to, if they call USCIS and they try to find information about your case, they could be told, they shouldn't be, but they could be told that your appearance has been superseded by somebody else's. But your employer cannot find out anything. Okay, this gentleman has posted the same question 3 times and then under a different name a 4th time. Please don't do that in future. If anybody does that, I won't answer that question. That's just unnecessary. Next question is Jeet to Mac T. Visa validity when visa type is changed. My wife has completed 2.5 years on L2. I have L1B. Oh, okay. So your question basically relates to how many years of H1 I can get if I have been on L1. And the answer is all the time you were on L1 will be deducted from the H1. But your wife was on L2. L2 time is not deducted. So she'll have a full 6 years. Okay. Ash 123456 says query on AOS did not amend H1B in past from previous employer. Your case history is a little bit long and a little bit confusing. I wasn't quite clear on all the facts, but let me tell you the law of adjustment of status, section 245K. 245K as in kite protects those people who are out of status or have worked without authorization. You will be forgiven any violations cumulatively up to 180 days. Up to 180 days. Okay? But if you leave the United States, come back, and then file 485, all the previous violations before your entry are forgotten. That's the way 245K is being interpreted. Okay? So if you filed AOS, adjustment of status 485, after re-entry, everything before re-entry is forgiven. And I think that covers your question. Let me just double check. You have traveled outside USA. If I join company E, I hope you're on the phone because I'm not quite clear about what your concerns are. And you were saying that your H1 violation by your employer lasted a total of 167 days. There are some issues here I'm not quite clear about. I hope you are here. Generically, I've told you what the law is. And if you join company E, really the main situation here is once you leave USA and come back on a proper visa, your previous violations for 245K purposes are forgiven. Okay. And this is again Ash 123456. Currently working for employer A on H1B visa. traveling outside USA, they are going to apply for him when he's outside USA. You will get an H1, but you should not receive um, an I-94. So you will have to come back and either go for visa stamping or apply for I-94 within the United States again. If, however, before leaving USA, you have already applied for a transfer / extension, and then you travel, there is no problem. Once again, if you are traveling, okay, you're outside USA, and a new employer files for your H1 transfer, you will not get an I-94. Now there's another possibility that the new employer gets you your approval and sends you the approval notice to wherever you are outside USA. If you enter the United States using an old visa stamp but the new approval, you will get the I-94. But let's say the transfer is not approved and you come back with the old employer's approval and you work with the old employer. Now when you want to convert to the new employer, you'll have to do one of the two things. Go outside, get a visa, well, not a visa stamp, but go outside and come back using the old visa if the visa is still valid, or get a new visa stamp if the visa is already gone, or apply for an I-94, which is basically refiling the H1 all over again. Okay. If, however, you apply and then leave, there is no problem. There's a problem only when you're doing change of status. If you were on F1 and then tried to apply for H1, and you left the United States after applying, your change of status is automatically abandoned. But when you're doing an extension or a transfer, you can travel after applying. Pharmacist. The question here is, can I have a part-time job on H1? And the answer is definitely. But the hourly salary must be that which is required by law. So if they are offering you 50,000, and let's say the prevailing wage for a pharmacist is 100,000, you can only work 20 hours a week for them for 50,000, because they are paying you at the rate of $50 an hour. Okay, so you can only work that which you're getting paid for. Part-time filings are allowed. Is it legal for two companies to apply for my H1B? The answer is yes. You can have 30 companies, 300 companies apply for you. You just cannot have the same company or related companies apply for you. More than one H1 for the same individual for the same set of companies is not allowed. But unrelated companies, no problem. You can have as many applications as you like. Here, they want to know if the fee payment date extension can be granted by National Visa Center. There really is no law on this issue. You should contact NVC and find out from them what their procedure is. This is not something that is legal. It's a matter of procedure. As to why they make you pay, that's their process. Even though you are so backed up in your priority date, you have to pay the fees now. Can you get additional time based upon the birth of a baby? No, I don't think that's a good enough reason, but you can check with the NVC. It might take you a few hours to get through, but you can contact them, and they also respond to emails. Okay. If you don't pay the fees within a year that they want you to, they will dismiss your case as having been abandoned. And that will get complicated to try to reinstate that case. Of course, if you come back into the US, you can always do adjustment of status. Next question is change of status to F1 denied from Goldie 2013, and motion to reconsider, reopen, MTR. This is a question about how can a student prove their financing for their education. Basically, you can have your family members and friends give affidavit of support or letters. Do a Google search or talk to your international students office. Okay, They should be able to tell you what kind of documents the government is going to accept to prove your financial capacity to undertake your course and to be able to support yourself. Okay, it's not that complicated. It's actually available on the web. Many colleges and schools, reputable colleges and schools, give you detailed guidelines on what you should submit. L1B to H1B conversion, Venkat SF. I'm currently on L1B with company A. They are applying for H1B this April. B has also an offer, also an H1B. What happens if company B H1 gets approved and not A? My understanding is from October 1st, my L1B is not valid with A. You'll have to start working with B. That's correct. That is correct. Main concern is if for some reason company B revokes my offer, I will be in trouble from October 1st. That is true. And have to leave the country. But you can go re-enter with L1B visa and you'll be back on L1 after October 1st. So you could leave on September 30th, go outside, maybe go to Canada, come back using L1B visa. On October 1st, you're back on L1B. What happens if both my H1B get approved? Do I have the option to withdraw H1 of company B? You can choose not to join them as far as immigration law is concerned. If you have 10 H1B approvals, you have to do nothing, just take any one of them that you like. But if you have a contract with these companies, you may have to have that looked at by lawyers to make sure they can't sue you. Tourist visa from Dhaval Doshi. I've applied for my spouse I-130 and K3 visa. She got tourist visa. Is there any procedure after she comes to US to change status? Well, that's fraud. If you look at the cases from our files, on our home page, there's a column that we all feed into. I just posted last week a case in which somebody in this situation, like your wife potentially would be, government held them to fraud standard. It became very difficult to win that case. It was a touch and go for a while there. So don't do that. Okay. If she does not get her green card in 6 months, can she go to Canada, Mexico, come back on a tourist visa? And the answer is this is a bad way to do things. I don't think people should try to enter on tourist visa unless they have made full disclosures to the consulate. If the consulate knows there is a K3 pending, they know that Dhaval Doshi, the husband, is here in the United States, then it's okay to try to travel on that tourist visa. If full disclosures are not made to both the consulate and the CBP at the time of entry, this can be a fraud issue. Be careful. Shazbel, Cuban Adjustment Act. So under the Cuban Adjustment Act, you are either paroled in or you come in, already in the refugee status. So the point is they have some discrepancy in when their green card was approved, and USCIS has said that they made a mistake. What you should do is contact your congressman. Normally, you can contact the Ombudsman's office also. Contact your congressman. They'll be able to help you in correcting this situation. Okay, next is, again, this is the gentleman who's posted the same question in triplicate and then again in somebody else's name. So I'm gonna answer it this one time, but don't do that, guys. I won't do it in future. AKS341. My job was terminated on Jan 13th. Filed for a visitor visa on the same day. Now I've got a job offer from another employer who would file my H1 petition soon. Excuse me. Would I need to travel out of US and get my H1B stamping before beginning work when the new H1 is approved? And the answer is yes. The way it works is, if your previous status has been terminated or has expired, terminated by loss of job, and you have like a tourist application pending, when the new H1 is decided, if at that time your tourist application is not already decided in your favor, USCIS will in all likelihood make you go outside USA for visa stamping. Not guaranteed, doesn't have to happen, but chances are that's what will happen. What is the shortest time in which a perm application can be filed with a new employer? I have 14 months. Well, plus 2 weeks remaining. It's difficult to say. If they have a pre-existing ad and recruitment that they can use for you, they could file the application in a couple of days. But if they are going to start from scratch, I would say 3-4 months at least, maybe sometimes up to 6 months. The attorney for my new employer says that I may need to spend 1 to 3 months outside of USA if the perm opinion does not come in time. Perm approval does not come in time. What is your opinion? And the answer is I agree with them. Depending upon how fast they can move, it's a good estimate. I think your employer's lawyers are guiding you correctly. What are the consequences of perm being denied? Well, you can file an appeal. While the appeal is pending, you can start getting H1 extensions once you reach that 1 year anniversary of perm filing. After I-140 approval, am I eligible to change to a different employer in a different job? Yes. You can carry your priority date forward, but you will have to start your green card all over again. The same or similar job criterion applies only to AC-21, which is I-140 is approved, 485 has been pending 180 days. Now if you change employers and you want to use AC-21, you don't have to start the green card again, but the jobs have to be same or similar. If you just want to use the I-140 priority date, then the jobs have to be same or similar. And you have to start the jobs do not have to be same or similar. Let me rephrase. I tripped myself up. There are two ways to carry forward some part of your green card. If your I-140 is approved, you can always carry the priority date forward and have a totally different job with the new employer. But the downside is you have to start your green card all over again. So priority date forward, any job, green card has to be started again. Under AC-21, the jobs have to be same or similar, but the green card does not have to be started again. This is the part where I-140 is approved and 485 has been pending 180 days. So the pro of that is you don't have to start all over again. The con is jobs have to be same or similar. The last question today is from Chandra Subhash. They want to know, I'm a US citizen and I want to run for public office in India. As far as US laws are concerned, we have no problem what you want to do in India. But Indian laws might limit the possibility of what offices you can run for. Mandal president, panchayat, etc. may be okay, but for legislative assembly, etc., you may have to, unless dual citizenship is fully enforced by that time, you may have to give up your US citizenship. By the way, I do a radio show every week, and this morning, Kavalji, who's the host for our radio show, she was saying that she talked with somebody from Aam Aadmi Party who was saying that one of their targeted agenda items was to make the dual citizenship more mature. So in other words, we can hope to see dual citizenship come into being. One second. Come into being. Well, I don't know how soon, but as soon as they can make it happen. Okay, folks, any follow-up questions, please press *5 on your phone. Only follow-up questions, nothing new. Press *5 on your phones, please. Three people have raised their hands. Okay, let's go in the order that people logged in. Oh, 4. Okay. All right. Let's start in the order people logged in. California, go ahead, please. You were the first one in today. I remember you. California, go ahead, please.
Hello, Rajeevji. Thanks for answering my question. I actually posted two questions separately because to avoid confusion. The
Sure.
first one is number 12,
Sure.
and I'm sorry it was a very lengthy question. And I now understand that. Are you already on question 12?
Yes, I am. I remember your question actually.
Okay. So I now understand and clarified it clearly that 245 case applicability from last lawful entry before you file adjustment of status.
Right.
So I'm good there. And then you also mentioned when 485 or adjustment of status is filed, they only consider all the status transfers from the last status or last lawful entry.
Correct.
So I was just trying to understand it again that all the things which happened before last lawful entry, they cannot open it or they do not open generally when they do adjustment of status.
They generally do not open those. Now,
Okay.
the only exception to this rule would be, or this policy would be, if the green card sponsoring employer and the employer who violated H1 regulations are the same employer. Are they?
Okay.
Are they the
So they
same?
are not.
Okay. So, yeah, if it was an earlier employer and you are no longer with them, you've gone out and come back again, I don't see how the earlier infractions, violations by the old employer can hurt you in any way. I wouldn't worry about it.
Okay, good. Thank you so much. So the next question was 13. This was about I'm trying to jump to a newer employer, and before I do that, I'll be traveling outside. They definitely won't file by the time I'm in US, so they will be filing when I'm in India. The, the, the lawyer mentioned that they would be filing the H1 transfer for future effective date when I'll be back in the country again. So what she mentioned is that I don't need to go out of the country, but again, I will come back in this country on my old employer's visa and old employer's, current employer's 797, and would try to change in a future date once I come back to the new employer. So do you think it's different from what you mentioned earlier?
No, I think there is a misunderstanding of the law here. I am, of course, always willing to listen to a contrary opinion. In my opinion, the fact that you are not physically present in the United States is what is important. On the date of the filing, if you are not physically in the United States, I-94 will be outside the US.
Okay.
Okay.
And then, even if it is a future effective date, if I want to change on that particular date or after that date, I have to go out of country, come back with a new I-94.
That's what
Because I think that's how it is.
that's what I believe, yes, sir.
Okay.
But of course, if you find
Okay.
something different, feel free to run it by me. I'm always willing to learn new things. Immigration law is a very complex area of endeavor. Nobody can know everything. But I'm quite confident my answer is correct.
Okay.
All
All
right?
right. Thank you so much. In any case, I think I can still go out and come back on a new I-94. Just wanted to make sure that it's not going to hurt my current employer's status by any
No,
chance.
no, I don't see any problem there.
All right. I'd ask.
Good luck, sir.
Okay.
All
Thank
right.
you, sir.
You're welcome. Bye-bye. Next one is North Carolina. One second. North Carolina, go ahead, please.
Hey, Rajiv. I have a question about I-130 and
Hang on.
and
Have you posted a question?
yes, I have already.
Which one is that? Which number? Do you know?
I think 17, I guess, 16, 17.
Okay, I'll find
This
it.
is the one.
The tourist visa question. If she comes in, two things you wanted to know, and I answered that. Did you have a follow-up? Go ahead, please.
Yes. We have disclosed about her I-130 and 129 as pending. and after that she got the tourist visa.
That's very good.
Now she will be traveling on.
That's very good. In her case, when you have made full disclosure to the consulate, if she's asked about her purpose of entry, she should let CBP know she's coming to visit her husband. And if they ask her, they probably will ask her, they probably will also hassle her. But if they let her come, not only, why would you go to Canada or Mexico? Just apply for an extension within the United States. Make it clear that she has made full disclosures to the consulate as well as to the CBP at the border, at the airport. I don't think you should file an AOS. I think that would be a bad idea until the K3 is approved. But getting an extension, or at least applying for an extension, should be okay.
No, I mean, I don't know how tourist visa works, but she has got a 10-year visa. So do we have to apply for any extension after 6 months of stay?
Let me explain to you how it works. A visa is merely a permission to land from your home country to the airport in the United States. So a visa is a permission to land at the US airport. At the airport, CBP decides how long you can stay.
Okay.
So even though you have a 10-year visa, that merely means in the next 10 years you can land at the US airports anytime. But that does not mean you're going to get stay for 10 years. Typically stay is given for 6 months or less.
Okay.
So once you are inside the United States and they give you 3 months or 6 months, you can apply for an extension before the expiration of that stay.
Okay.
Okay? Anything else?
Okay. Yes. About the change of status as well. I mean, if we apply for change of status, I mean, is it possible, very first one, is it possible to apply for change of status from tourist to pending green card application? I'm
hesitant to advise that. I'm hesitant to advise that because government can still take a dim view even despite all the disclosures, because we haven't disclosed that I intend to apply for adjustment of status. Okay, so I would be reluctant to say that that's okay. But you know what? Once she gets in here in about 3 months' time, talk to me again.
Okay. One more follow-up, please.
Sure.
Let's say if we come on a tourist and we get the K3 approval, she goes back and gets the K3 and comes here, and then she gets a green card. Can we follow that process?
Yeah, because K3 definitely allows you to file for adjustment of status.
So I mean, by that way we can get the EAD earlier than waiting for a green card.
I don't know what is going to be quicker. Here is the interesting thing. The processing time for a K3 and I-130 are quite close. Okay. And I mean, the green card could be just as quick as a K3. It's difficult to say. And the law is, if the consulate receives intimation from the USCIS that the I-130 has been approved, not just pending, they will decline to issue the K3. They will say, wait for the green card, which is okay.
Okay.
So let's take it step by step. Let her come into the United States. It's interesting. I've never looked into the issue. Can somebody apply for a change of status to K3? I don't think that you can. Because what if you could go from tourist visa to K3 and K3 to adjustment of status? That would be so much easier. I don't know if you can do that. I'll have to look it up. Typically K3s are always given by consulates, but can you do also a change of status? My thinking is, what if she enters on a tourist visa? Okay. Then after a few months, if we explore the idea of doing a K3 within the United States, is that possible? I do not know. I don't think so. Never heard of it done before, 30 years of my practice, but maybe it's possible. Certainly worth looking into. Okay.
Okay. So you're saying that within a US change from tourist to K3, you don't know it, but
maybe possible. It may be possible.
Okay.
But don't do it.
I mean, I would prefer to be. I don't want to take chance. I would rather have her going back and get the interview with the.
No, but you can.
Come back on K3.
You should let her come. If she's able to enter the United States, after a couple of months, we can talk again.
Okay.
But don't do anything first 60 days after she enters.
Okay.
Okay? Good luck.
All right. Thank you.
You're welcome.
I had a similar question last forum, and you advised me to disclose and go for a tourist visa, which I did, and we
Excellent.
got the tourist visa now.
Excellent. Well, that's very good.
Thanks for that advice.
She must have interviewed very well, because normally they will not issue a visa.
I don't know, but she got it this week. So
Excellent.
That's why we are
Well,
curious about the thing.
That's good to know. Good to know. Sometimes what we think of as possibly successful actually turns out to be so. Government is full of surprises, good and bad. Good luck, North Carolina.
Thanks.
You're welcome.
Thanks.
What am I doing here? Just 1 second. One second, guys.
You are now a host.
Okay. The last, is it the last? Yeah. The last raised hand, or maybe there's more than that. Give me 1 second. Oh, yeah, there is more than that. There is at least a couple more follow-up questions. Massachusetts, go ahead, please. Area code 857. Area code 857, Brookline.
I'm sorry. Hello, Rajesh, sir. I'm sorry, I was on mute.
No problem.
Can you hear me?
I can hear you fine. Please go ahead.
Yeah. Thanks for answering these questions. Actually, I had a question. My F1 got denied since they feel like there is a financial issue. I did submit the affidavit of support from my wife, as you said, but still they said there's not enough money to support your living expenses and college fees. So now they denied it, but they gave me option to file a motion with I-129B form. And my question was like, I do have enough amount to show them whatever the amount mentioned on I-20. But, I got this money from my friends. And do I need to show them, like, how did I get that money in my account?
Normally, I have not known USCIS to ask for the source of your funds in a student visa setting. But do go over, like I said, almost all the reputable schools have a detailed listing of the documents you can submit and will be accepted by the government as your financial backing. Go over the list, see what else you can provide. This is a one-shot deal, provide as much as you can.
Oh, okay. And I don't need to submit all the documents again, right?
No, as many as you can. These are much of the evidence could be cumulative. You don't want to beat the same drum over and over again. But if there is evidence that tends to underscore or make your position stronger, use it. Why not?
Okay.
Okay.
I was wondering, like, it 3 months back when I got an RFP and I sent them whatever the money I had in my account, I sent them 3 months back. And now all of a sudden, like, how would explain that, I have enough amount to support myself for the expenses and the college fees.
You should get letters from friends, affidavit of support, as well as if you have money in the bank and it's genuinely yours or borrowed money. You can describe that as borrowed money. I don't see any problem with that.
Yeah, that's it. So I didn't find any format for for borrowing money from the friends, but the affidavit of support is like, we need to submit friends' tax documents and salary slips to prove that, he's supporting me. So that is different, and this is different. Like, I got money from them and I have that money in my account. So still I need to get affidavit of support from them?
No, you don't need to. But my concern is that if you have access to the affidavits of support or letters from friends, people who have lent you money, they can say a letter, give a letter saying that I intend to support XYZ in the amount of $7,000, and I've already given him the money. I've already loaned him the money.
That's on the plain paper is fine.
I can't hear you. What did you say?
I'm sorry. If that's on a plain paper, is it fine, or
It's just a letter on a plain paper should be okay. I don't see any problem there.
Oh, okay.
Okay.
All right.
Good luck to you, sir.
All right. Thank you very much.
You're welcome.
Thank you very much.
You're welcome. Bye-bye. Okay, we have two more follow-up questions, and then we'll start with the new ones. Okay, let's look at Illinois. Go ahead, please. Illinois, area code 312. Illinois.
Hi. Hi. Actually, first of all, I would like to apologize for posting the questions again and again on the site.
Oh, you are the
I
one.
see my post, so yeah. Hi. So I just thought I was actually surprised when you answered my question because I could not see my post. So I tried with multiple users.
Yeah.
Okay. I thanks for answering my question, but I could not understand the answer to the first one. So if you could just tell me, like, can I go for stamping? Can I go for transfer of my H-1B without stamping to other employers from India? Because I'm in India.
You can go for transfer. See, distinguish visa from H1 application. Okay, H1 application is made within the United States to USCIS. Visa is something you go to the consulate for, right? The H1 application or petition is filed by your employer. So right now, you have an approval from one employer, employer A. You've got your visa stamping from employer A. And the question is, there are two parts to your question. Can an employer B in the United States file for my H1 and I will not be subject to the quota, even, hang on, even though I don't have any pay stubs from employer A? And the answer is yes, a new employer can file for your H1. Go ahead.
I'm sorry. Actually, my question was, I don't have the H1 stamped. Before stamping, can I transfer it to some other employer from India itself because I'm in India?
Yes, you can. The stamping is unnecessary as long as you have an H1 approval from any employer. That same H1 can be taken over by another employer through an application, through a petition, and you will not be subject to the quota.
Okay. And then I can go with, for the stamping with the other employer.
Yes, ma'am.
Okay. Thank you very much for answering.
You're
my
welcome.
question.
Good luck. Okay. And the last raised hand is also from Chicago, area code 773. Illinois, area
Hi,
code.
Rajiv. Hi, Rajiv. This is not follow-up question. I have separate question. So
You're gonna have to wait. You're gonna have to wait.
Okay. Sorry about that.
No problem. Okay, guys. Any questions, new, old, it doesn't matter. Please press *5 on your phones. Any questions, old or new? So we have a total of 6 hands. I will start with in the order in which people logged into the conference. So whoever logged in first, I will go with them first. Let's start with Baytown, Texas. Texas, go ahead, please.
Hello.
Yes, ma'am.
Yes, sir. Actually, currently I am on my H-1B visa, and I had a baby like last year in the month of June. So it's been almost like more than 6 months that I am on my maternity leave. So, what is the time limit for the maternity leave that I can be on H-1B without any pay?
Okay, I think you posted this on immigration.com also, right? I think I remember a comment from you.
Yes, sir. I have sent an email actually.
Oh, you had sent an email. Okay, I remember dealing with this question earlier. See, this is a highly fact specific question. Normally, whatever the normal time for a maternity leave is, I don't know how much that is, 4 weeks or 6 weeks, that is, of course, perfectly fine. On top of that, if you have any medical reasons why you cannot go back to work, you should be able to document those, and then as long as you have that medical reason, it's okay for you to be without pay and without work. But if you have no medical reason and for just personal affection for your new baby, you want to be at home, you could have a problem. You'll be better off converting to some other status.
So is it fine, like, if I can have my employer letter for that, like, or do you want me to have the medical letter from the hospital?
Your doctor has to tell the USCIS eventually if that question ever comes up. It may not come up, but if the question ever comes up, how are you maintaining status? At that point, you'll have to show that there was a medical reason. The doctor advised you not to go back to work.
Problem here is, like, actually currently I would like to change my status to H4. What would you suggest? Like, do you want me to go to India and get stamped for there, or can I change it from here itself?
You have a new baby, traveling will be a hassle. Try to get H4 right now within United States. Your I-94 is still valid, it's not expired, has it?
Yes, sir.
Okay, so apply for an H4 within the United States. In 3, 4, 5 months, you should know whether USCIS is going to give you any grief. They probably will not, but do it quickly. Don't wait forever on this. And if for some reason they refuse to give you H4 within the United States, you can always go to Canada, Mexico, or even India to get your stamping done. Okay?
Yes, sir. And last question is, like, and my husband has applied to the green card too, and his I-140 has got approved. And do you think, like, will there be any issues at the time of I-485 when he want to add me to that? Like, if I don't have the pay stubs at this time, like, for the 6 months.
If you are not out of status for more than 180 days, you should not have a problem. This is section 245K. I talked about that just a few minutes ago. The thing is, up to 6 weeks, I think is quite normal. So if you subtract 6 weeks, if you have indeed been out of status, it's not been more than 180 days. I think you'll be okay.
Okay, sir.
Okay?
Thank you, sir.
Good luck.
Thank you, sir.
You're welcome. Okay, let's go on to the next person. I can't even say this properly. Metuchen, New Jersey? Metuchen, New Jersey?
Yeah, hi Rajiv. I have a question regarding H1B extension.
I have
Naturally, visa.
I have a question about the name of your city. Is it Metuchen? Is that how you say it?
Metachin actually, New Jersey.
Metuchen. Thank you. Okay, go ahead.
Yeah.
Your question is?
Yeah, I have. Yeah, H1B extension process. My H1B is expiring in July 2014, and I would like to know how soon can I apply for extension in Indian process.
Okay. First of all, H1 extension can be applied 6 months ahead of time. Okay. So you said your current H1 is expiring when now?
July 2014.
So February you can apply for your H1 extension.
Okay.
and my passport validity is September 2016, and my I-140 is also approved. So means if my employer is going to file H-1B petition, right? What would be the eligibility of getting the extension? It's for 3 years or till the expiry of the passport?
No, they should give you an extension for the entire period. I have never had any issue with passports. Typically, if somebody is close to their passport expiration, um, the fact that they've applied for an extension of their passport is never even questioned by USCIS. I personally don't remember any case in which we've had a problem. So I think you should get 3 years.
Means approval as well as I-90 for both, right?
That is correct.
Okay, okay. And last question is, suppose a client letter is required for extension process,
Definitely.
or can we submit the vendor letter and contract if the client does not provide the letters?
It gets complicated. It becomes chancy. Usually client letters are important, but if you have a contract between the vendor and the end client that sufficiently describes everything that USCIS wants to see, then client letter could be dispensed with.
And let's say in the extension process, my project gets over, right? Is there any way we can handle the situation, Rajiv?
There's no way to handle it. What you will end up doing is, if it gets expired, you can file for another H1 as quickly as possible and explain to the government that the project ended unexpectedly and to please give me status and extension and transfer within the United States. They may not do that. Worst case scenario, they'll make you travel outside for visa stamping.
Okay, so means I have to change the employer in that case, right? I cannot use my same employer, right?
You can use the same employer, different project.
Okay, for different project.
We've had cases where we actually submitted an amendment, an amended petition while the first one was pending, and USCIS did forgive our client, and they did give us I-94 within the United States in this kind of circumstances.
Okay.
But you know what they require? One thing I want to caution you, they want to make sure that the first case was approvable when filed. So let's say your project got over and you filed an amended petition. They are going to say, okay, show us the client letter from the first project to show that that case would have been approved.
Okay, okay.
Okay?
Yeah, sounds good. Thank you so much, Rajiv.
You're welcome. Good luck.
Thank you.
Okay, and I can't even say this name of this area. This is from New York. Go ahead, New York. New York.
Hi, Rajiv.
Hello.
Hi, Rajiv. Hello.
Yes, ma'am, I can hear you. Go ahead.
Okay. Yeah. I'm currently on my OPT. I just started my OPT extension, and I've been with the same employer since I started my OPT. Now the problem is I want to go to India in November, and my OPT is expiring in June 2015. So do you think it would be a problem because like re-entry would be a problem on OPT if I go in November?
Do you have a visa, F1 visa?
Yeah, my F1 visa was valid for 5 years.
And you have never been without work, at least not more than 90 days on OPT?
No, never. Never. I've been working since I started my OPT.
When are you planning to come back?
First week of December.
And is your employer filing for an H1?
Yes, I would have them file, but the problem is the filing would be on 1st April, and I'm going before that. So I don't know. How it works. Would I have to have them write that they are going to file my sponsorship?
Okay, hang on a second. I'm a little confused. Let me get your facts. Okay, let's begin.
Okay.
When does your OPT expire, ma'am?
June 2015.
Okay, is that 17 months?
Yes, it's a 17-month extension.
Okay, so the 17 months is expiring in June 2015. When you enter
Yes.
in December, there's only two possibilities. Either your H1 has been approved or it has not been approved. If the H1 has
I have never filed for H1 yet.
you're filing in April, right? This April or no?
No, not this April, next April.
Then I don't see any problem in traveling.
Okay, so if I travel on my OPT only, like I'm not having them do the sponsorship this year. I'm going to do it next year.
I think that's fine.
So which means I'll be So that should be an okay, right? To travel in November?
Carry a letter from the employer. Carry your pay stubs showing that you've
Uh-huh.
been working all the way through. I think you'll be okay. I don't see any problem.
Okay.
Okay.
Okay, and one more question. Can I would it be a negative effect if I also go to India for a week in June or July?
No, you can go as many times as you like. I don't see why not.
It shouldn't be a problem, right?
Okay,
If I make like 2 back-to-back trips.
One thing I want to confirm, your total time outside USA will be how long?
4 weeks in total, 4 to 5 weeks.
I don't see any problem. Say if you were gone for 90 days or more, I think I would need to worry. Is that going to be a problem for USCIS? Will they say, oh, you're trying to get around the regulations, you're not working? But if it's just 4 or 5 weeks, I don't see any problem with it.
Okay, and let's say I apply for H1B in April 2015. And that H1B will be valid from 1st October next year, right?
Right.
So what would be my status between June to October?
It's called cap gap extension. Read up on it. Cap gap extension. You can continue working.
Okay.
You can continue working, but you can't travel during that time.
Okay. And would I be able to change my employer in that time frame?
I think that's a little tricky. There are a number of variables there. Go to the ICE website. ICE has a frequently asked questions on cap gap extensions. Read up on that.
Okay, all right, thank you. So my main concern is this July and November trips. It shouldn't be a problem, right?
As long as the total duration outside the United States is just 4 or 5 weeks, I don't see any problem.
Okay. Thank you so much, Rajiv.
You're welcome. Bye-bye.
Bye-bye.
Okay. Let's go on. Oh, come on. Computer. Area code 773, Chicago, Illinois. Go ahead, please. Illinois, area code 773. It's a cell phone.
Yes, Rajiv. Hello.
Go ahead.
Yes, Rajiv. How are you doing?
Good. Tell me what's going on.
Yeah, Rajiv, just I have a question regarding H1 amendment. Right now, I'm working in North Carolina, and I will be finishing the project in 2 or 3 weeks. But my next project would be in Texas. So I want to find out whether LCA, just amend the LCA is enough, or I need to amend the whole H1.
Whole H1.
Okay. Because my company lawyer is saying that, it's still you are in North Carolina, so if we amend your LCA, that will be fine, he said.
This logic completely escapes me. Either this gentleman knows a lot of law that I've never heard of, or he's wrong. Okay?
So what do you suggest, like, if I want to make sure on this one?
They should file an H1B amendment.
Okay. Because my company is also telling that, like, lawyers, saying that, LC amendment is fine, then why you want
Tell them to give it to you in writing. Tell the lawyer to give it to you in writing. And if he gives it to you in writing, let me know, because I'll probably need to file a bar complaint against somebody who's going around giving wrong advice.
Okay. All right, Rajiv.
Okay.
So
No.
So even if I change the city, and then I have to file the H1 amendment.
Look, here is the law. This is what USCIS thinks as of today. I don't know what tomorrow brings. As of today, if you change cities so that the cities are more than normal commuting distance away from each other or in a different wage zone, you have to file an H1B amendment.
Okay.
So if you move within 40, 50 miles, maybe even 60 miles in the same wage zone, it's probably okay. But listen to the second part. In the second part, if you change job descriptions or change clients or projects, even within the same building, you have to file an H1B amendment.
Okay.
The only time you do not have to file an H1B amendment, an LC amendment is enough if the same project, same client, same job description gets moved within 45, 50 miles of where it was approved for.
Okay.
That's the only time you do not have to file amendment. Every other case you have to file an amendment.
Okay. And like Raju, do you have any documentation on your website so that I can send to him?
You can play this recording for them. I don't know. Maybe it's out there somewhere. I don't remember if I've ever answered this question in writing. I may have. Look in my blog, but I don't have anything in writing that I can cite to at this point.
Okay.
All right?
All right, Raju. Thank you so much. Appreciate it.
You're welcome. Good luck to you. By the way, one point of just common sense, if the lawyers give it to you in writing, at least you are protected to a large extent. Not 100%, but you are protected to a large extent. And I can give you this as a guarantee almost that they will not give it to you in writing.
Okay.
Okay?
All right, Raju.
Good luck.
Thank you so much.
Yeah, this is either somebody who is not experienced enough or somebody who is just not careful enough. One of the two.
Okay.
Okay, but when it comes to writing, every lawyer wants to make sure they're not misadvising. So then they will hit the books and probably find out very quickly that what they are thinking is incorrect.
Okay.
Okay?
Oh.
Good luck.
All right, Raju. Again, thank you.
You're welcome. Bye-bye. Okay, last question, folks. I won't do any more after that. And in fact, this is the last raised hand anyway. So let's go with Charlotte, North Carolina. Charlotte, North Carolina. Go ahead, please.
Yeah, my name is Sherry, and I have a wife who is a green card holder, and she has gone to India for over 5 months and 25 days. She has 3 kids who are U.S. citizens, and she is actually sick and she cannot come back within the 6-month period. Will that be a problem at the port of entry, or?
Yes, it can be. It can be. Did you say this is your wife or this is somebody else? I'm sorry, I didn't catch that part.
This is my wife. Yeah.
And you are a U.S. citizen, you said?
I'm a green card holder myself.
You are a green card.
I have 3 kids who are U.S. citizens.
Okay. Now, here's what happens. If she's outside USA for 1 year, she will automatically lose her green card. But if it is more than 6 months and less than 1 year, they can question her extensively at the airport why she was gone this long. Primarily, they are concerned that is she really considering USA as her permanent home? So, for example, if she has 3 children, where do they go to school?
Temporarily, they are going to school in India.
Yeah, see, all these become grounds for taking away green card because it looks like she has actually moved to India. Okay, let me ask you some more questions. Is there a reason for such a extended stay in India?
No, actually, she's undergoing some treatment for weight loss and things like that.
Okay, well, if there is a doctor's certificate or some kind of information on that, and there really is a good reason, and the fact that you guys are still talking to each other, there is communications between the two of you. She's not lost her ties to the United States. I think she should be okay as long as there's a genuine reason for not being here.
Okay.
Okay.
So there is a possibility that they can question her at the Port of Entry.
Yes, there is a possibility. One thing I want you to know, if you have a green card, it is my understanding at the airport they cannot refuse you entry even if they want to take away your green card. What they can do is take away your green card and tell you you'll be hearing from the immigration court, you have to report for proceedings, but they have to let you into the United States.
Okay.
So at that point, if they indeed take her into proceedings, which is unlikely, if they do take her into proceedings, you'll have time, you can get a lawyer, you can go to immigration court. It takes a year, 2 years, and resolve it before the judge.
Okay. And she is qualified for citizenship like in 2015 December. Will this continue to stay outside like for more than 6 months count against her? Because
definitely it will count against her. There has to be a very good.
What if she comes back like?
What?
If she comes back like in the 8th month or after 7 months.
Yeah, she's got to any stay outside the U.S. for more than 6 months. She's got to have a very good reason for it for citizenship purposes.
Okay. So if that is the case, if I bring her for a week here before 6 months, which is due next week, then she stays here for a week and goes back. Will that?
She's okay for green. She's okay for green card, but she still has a problem for naturalization. Because they can still look at that period and say, well, in the 12 months period, you were outside USA for more than 6 months. They can create issues for you.
Okay, when they do 12 months count, do they count year-wise or they count continuous 12 months?
They
Because
just any 12-month period.
Any continuous 12 months period?
No. Let's say she comes for, look, I'm going to have to hurry. I've been on the phone twice the amount of normal time. I'm going to make it very simple, and this is the last comment I'm going to make. The way it would work is, let's say she's been out for 5 months and 20 days. Okay, she comes back for 2 weeks and she leaves again. And then she's gone 5 months. In 12-month period, she's been outside for 10 months. So they don't go by calendar year. They look at any 12-month period and say, in any 12-month period, have you been outside for more than 6 months? That's my understanding. That's the way I've seen them do it. Okay? Good luck. I gotta go.
Thanks.
You're welcome. Thank you, folks. I will see you again the week after the next one, and I'll talk to you then. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.